So, welcome for the old who came last week and for the new who are here this week. As I mentioned last week, we have an important task to learn or relearn the what, the how, and the why our founders dedicated themselves in establishing a government that the people would govern. In summary, last week we spent time discussing the importance of civic virtue, both as a personal self-governing pursuit, and then as our founders realized the need as a public self-governing essential component if the government they were creating was to succeed. So today, we will embark on the specific principles that this government must adhere to, as well as the rights that this government must protect. Part of lecture series, part 2, is civic principles and rights. And as I mentioned last week, this will be a little bit longer than last week, only because we've got quite a bit of business to really talk about. So I'm going to revisit a couple of things, and I'll do it quickly for those of you who saw it last week. But my organization is called the Massachusetts Center for Civic Education, which I began in 2015. And our mission statement, as you can see, definitely discusses the importance of all of the things, that we're trying to do for all groups of people. Even though 2 of our major programs, the We the People program, deals with civic learning, and our Project Citizen program deals with civic engagement, are dealing with mostly our students in grades 5, 8, and high school levels. But the component that we're dealing with tonight, this group of this program is called Civic Lyceum, which is what we're dealing with currently. And as you can see, the Civic Lyceum program is something that was started in the Greek times with Aristotle, and the Lyceum movement was intended, for adults. And as I mentioned last week, the American Lyceum movement was started here in Millbury in 1826. So we'll be celebrating our 200th birthday of the American Lyceum movement next year. It really grew. It was over 300 lyceums that were in different communities all over the Northeast, as well as through the Midwest. And then, notice that what we're trying to do is to try to create the importance of the Lyceum movement through our Citizen Lyceum as we try to deal with greater understanding of the civic and important understanding of the principles, of the values, of the institutions of our current government. So virtues are the qualities individuals should aspire to, and that the people through their government should exemplify in promoting the common good. And that's what we did or tried to do last week. Today we'll look at the principles as the ideas that guide how government should achieve its goals and purposes. And if you remember, we're going to do this at the very end of today. We looked at the preamble of the Constitution, and we looked at the 6 various purposes, and we'll see at the end, where the preamble of the Constitution is aimed, at those 6 goals, those 6 purposes, which we're going to be talking about. Well, the 3 major principles are what I want you to come away with today. So if someone wants to just change the virtue sign to the principal sign, you'll see that if we can all remember these three terms and what these three terms mean, you will at least collectively understand the three major principles of government that the founders really wanted to emphasize. And if we don't get through emphasizing them enough today, we definitely will be doing this next week. So the notion of liberalism, and let me caution you right away, the word liberalism does not mean what it means today. Liberalism, okay, means that it refers primarily to the political and economic philosophy that centered on individual rights, equality before the law, and protection of personal freedoms from an arbitrary government and interference. So liberalism was very important at the particular time in which the time in which our government was formed, and it intentionally was focusing on something relatively new in the history of our time, relatively focused on this notion that everyone had individual rights, natural rights as they're often called at that time as well. And these were supposed to be everyone's rights, not aimed at a particular group or particular entities, but everyone was born with these rights. Some would argue that they were God-given. Others would argue they were simply there because you were born. Liberalism was that notion that these needed to be protected. There were two new concepts that you're going to see and hear about that's connected to this liberalism. That's also refreshing and new at this time, that's inserted in documents that you're going to see. This notion of the consent of the governed. We briefly talked about that last week. In other words, the individual rights that we have are going to be connected to the consent of the people who are being governed. So whatever government is created needs to have the approval of the governed. And the second, of course, another term that's used is called popular sovereignty. And popular sovereignty is, of course, the right of the people to give that approval. And that right is, of course, through the vote. So liberalism is extremely important to our framers and our founders. How did they come up with this notion, for example? Because this was relatively new. Well, the Enlightenment thinkers came up with this notion of, okay, what if there was no such thing as a government? What if we lived in a state of nature? How would things work? And in thinking that through, they said things would be pretty uncertain, pretty unsafe, chaotic. So then they said, okay, then that's the reason why we need a government. Now they had to determine what kind of a government. Well, as we've just seen, if you're talking about liberalism, that type of a government that some of these philosophers, like John Locke, like Algernon Sidney, they believed that that type of a government should be one in which the people who are being governed should approve, should give their consent. They didn't all agree to that. You may have heard of Thomas Hobbes. He too, believed of the state of nature. But Thomas Hobbes, believed that the monarchy was a best form of government. He didn't believe, that people would have the ability to govern themselves. So he came to the same conclusion that a state of nature, could only be solved by a government, but he didn't come to the same conclusion that the type of government should be one like a republic. John Locke, writes in his 2 treatises on government in 1692, the state of nature has a law of nature to govern, if which obliges everyone, no one ought to harm another in his life, liberty, health, or possessions. Well, that's nice. They shouldn't do that. But that doesn't mean there's any guarantees that they will. Therefore, a government is necessary. So here we come to the Declaration of Independence. So in addition to the inalienable rights, that we talked about last week, of life, liberty, and the pursuit of happiness, bingo, Thomas Jefferson says, we're going to have a government based upon what? The consent of the governed. And the source of authority? Popular sovereignty. Well, let's look at the second paragraph of the Declaration of Independence. As we mentioned last week, that we hold these truths to be self-evident, and I mentioned to you then that even though we might not have said it was self-evident, in those days it was, because everyone grew up believing, that these types of things, were true. They knew that, or they believed that. All men were created equal. Oh, yes, well, there were some little, exceptions, apparently, at that particular time. That they were endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness. And we looked in last week as to the meaning of the pursuit of happiness. That to secure these rights, to make sure that these rights are indeed protected, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. Whoa! Yikes! Some people would love that. But notice the next line, or the next clause. And to institute new government. He's not advocating anarchy. He's obviously saying one must institute a new government to do what? Institute a new government that is going to do what? Protect those inalienable rights. So the bottom line, if you look at your your constitutions that were handed out to you today, okay, on page 6, there's a little bit more that I didn't put down on here, but you'll notice, okay, that he goes on to say, prudence, one of our virtues that we talked about last week, prudence says you're not going to go changing governments, okay, for light and transient reasons or causes. Because what he's trying to say is people are ordinarily not really going to change governments quickly and always wanting to do that or thinking that they could do that. As he, I think, says, people are usually willing to suffer the consequences rather than, okay, abolishing a government. So if you look a little bit further, okay, in his writing, you can see, okay, that he essentially recognizes that the masses may not like things all the time, but the bottom line is he is essentially recognizing that even though you're upset and you don't like what's happening, it's unlikely that people are going to turn around and say, okay, guys, let's go ahead and get rid of this government. It's not going to be that easy to do. However, if we continue to read this document, which we're not going to do, okay, you would, okay, see that he came up with a lot of reasons as to why this country, at this time, was going to declare its independence from Great Britain, and he gave 27 reasons why. Second principle, republicanism. Again, this is not to do with a political party. This is small r republicanism. It deals with the notion of a republic. And we have two quotes because there are two pieces or two parts to it. One has to do with, well, let's put it this way. There were in 1790 at census 4 million Americans living in the United States in 1790. Is it feasible for 7 million people to vote on the legislation or laws? You can even nod your head. I mean, it's okay. So I'm going to say, if you don't think it was reasonable then, I'd have to say in 2025 with 340 million, I'd have to say you probably don't think that would be reasonable either. But the bottom line is the notion of a republic being served by representatives, okay, was something, okay, that was feasible and was something that typical republics, as in the Roman Republic, was expected. And that's what our founders, okay, wanted to have done. So the article here, or the quote here, references the Federalist Papers. By the way, I will be talking about the Federalist Papers again next week, and I'll bring in the Federalist Papers so you can see, okay, the 85 different essays that were written, and no, you won't have to read them. We may define a republic to be a government which derives all its powers directly or indirectly from the great body of the people and is administered by persons holding their offices during pleasure, for a limited period, or during good behavior. And next week, when we talk about institutions, we'll define that a little bit further. But there's a second part that doesn't get taught very often in schools or is not often referenced. And the second part is the importance of civic virtue. The second part, okay, refers that in all cases where power is to be conferred to the representatives, the point first to be decided is whether such a power is necessary to the public good. as the next will be in the case of an affirmative decision to guard as effectually as possible against a perversion of the power to the public detriment. In other words, we expect our representatives to make decisions that are promoting the common good. That's what we expect them to be doing. And that's part of this notion of republicanism. And that's part of Federalist Paper number 41. So, John Patrick, a very wonderful, scholar from the University of Indiana, who passed away, unfortunately, just about a year and a half ago. He's a good friend, and he wrote a book called Understanding Democracy. And this quote explains, I think, very, very well, this notion of what republicanism is. The theory that emphasizes the participation of citizens for the common good of the community. The responsibilities and duties of citizens are paramount, and the exemplary citizen readily subordinates personal to public interests. I want you to think about what that says. In contrast to liberalism, which is concerned primarily with the personal and private rights of individuals, republicanism stresses the public rights and obligations of citizens to cooperate in support of their community. You see a problem here? So, in balancing the principles of liberalism and republicanism, tensions arise between the protection of individual rights and promotion of the common good. So what examples can you come up with in your own lives that illustrate this conflict? And if you want, I can give you an example to get you started, unless you think you know what you want to say. But I'll take a very easy example. Smoking. When I was growing up, smoking was as pervasive as it could be. Everybody seemed to be able to smoke, and they smoked in everyone's home, and they smoked, all the time. It wasn't really until the 1990s, despite the fact in the 1960s, you added to that little pack of cigarettes, this is hazardous to your health. It wasn't until the 1990s, until science had basically said secondhand smoke and people who were not smoking were as much at risk in damaging their health as persons who smoked. That all of a sudden, your government decided that you could not smoke in public venues any longer. So we went from individual rights, wherever, whenever, any place you wanted to, you could smoke. And then all of a sudden, you couldn't smoke in restaurants, which was commonplace before. You couldn't smoke in any areas, that you wanted to, whenever you wanted to. You couldn't do that any longer. You could smoke in your own homes, that was still but you couldn't do it. So the bottom line is the government took into their own hands and made the laws that restricted the individual right of smoking and basically said no. Any other examples? More current, perhaps. Yes?
Airport security, going through it and being examined in the booth having you take off, well, you don't need your sneakers off anymore, but also having people can go through your luggage, they can open it up. And I think when that first came up, there was a lot of grumbling where people felt their rights were being violated because they had to go through security, both they and their luggage.
Perfect. Perfect example. In other words, again, your individual right versus the common good. Perfect example. Anyone else? Yes?
COVID vaccines.
COVID vaccine. Yeah, there was certainly an uproar. There's certainly a lot of people still, concerned about it. Yet, the government, made that decision, and people needed to follow those mandates. Didn't mean that they liked it, but they made the mandate for the common good. Anyone else? Yes, sir.
Speed limits?
Say that louder.
Speed limits on roads?
Speed limits on the roads. Like we pay attention. Excuse me. But you're right. I mean, that's the purpose behind it. Absolutely. Absolutely. Yes, sir.
Loss of privacy?
Say that again.
Loss of privacy, privacy.
Exactly. Can you give a specific example?
I was thinking more on a macro where, years ago, privacy was important to you. Now your privacy is generally eliminated.
Well, a specific example, though, because, what you're saying may be true in a specific area. I mean, there are areas of privacy, that you're correct, but, privacy is a pretty large, area.
Okay.
Yes, sir.
Seatbelts.
Seatbelts. Yeah, you can be stopped. There's a law for that. And again, people are concerned with it, but there's a law, that specifically says that if you are stopped, you can be arrested or cited, if you will, if you don't have your belt on. That is correct.
Texting while you're driving.
Texting when you drive. Excellent.
Background checks for guns.
Background checks for guns. In some states, they have them. Yes?
Fluoride programs.
Fluoride programs. Again, in some states, you have them. The bottom line is, I think many of you understand, what I'm talking about, this notion of this universal belief that you can do whatever you want because you have these individual rights is necessary to be limited when it comes to the common good, if that is warranted and believed by your representatives to create laws in order, to restrict that individual right for the common good. So you understand. Good. Constitutionalism, simply put, limited government. What is it limited? What's limited? The Constitution limits the government. It has clauses within the Constitution that basically says what the government cannot do. These are limits on the government. These principles were important. As you probably can imagine, thinking about your history, why did we go to war against the British? There were things that the British were doing that we did not think was appropriate. There were things that they were doing that we thought they should not be doing. So we put into the Constitution limits on what our government could do to the people. Those were the limitations. Thus, constitutionalism is going to be a huge principle. So, in packaging principles, I put them into these three categories. That make sense? So, limited government means that officials cannot act arbitrarily when they make and enforce laws, Government officials cannot simply do as they please. In other words, this is called the rule of law. It's not just the people that have to follow the laws, but also the people who make and enforce the laws that must follow the laws. That's what's called the rule of law. This was clearly, part of what is meant by constitutional. Yes, sir.
So, in your studying, when did executive orders change all that? An executive order by a president?
The executive orders were always a part, of what a president, could do. Initially, they were done very rarely, but they were done at a time in which either the Congress was not in session and there was something that was needed to be done with some immediacy. Let's be understood, that in the beginning, the Congress did not meet, year-round. They met, for a few months, and then their travel was kind of difficult. It was not easy to get to and fro to wherever they were meeting. And so, again, they had the right to do it, but they didn't often do it. It was done as an emergency type of thing. 20th century, 21st century, the increase in use of the executive orders was much, much more prominent. Yeah. The rule of law means that neither government officials nor common citizens are allowed to violate the supreme law of the Constitution or the laws enacted in accordance with it. So the rule of law is a basis of this constitutionalism that the framers of our government, were very, concerned about. Now, part of what they put into the Constitution often came with the British influences that came way before the American Revolution. I'm going to try and deal with this quickly. I think you'll pick up some of this, from your earlier knowledge. First of all, the Magna Carta. Look at how early that was. That was in the year 1215. Now, King John the First took over for Richard the Lionhearted, who had died as a result, of injuries from the Crusades. And his primary issue was he was violating the rule of law. And he wanted to start wars with France. He wanted to tax, his nobility. And, he was just passing all kinds of different rules and laws that he wanted in order to have different opportunities to use his armies and things of that nature. And the barons and the nobles, said enough already. And they basically said, no, we can't do this. So they met him and they cornered him, and they had 63 clauses. And the two most important to our founders was clause 39 and 40. And those, are going to be, I'm using their direct words, but you can see from those words some of the things that we imported into our government. No free man shall be seized or imprisoned or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land. So that's the roots, if you will, of the trial by jury. In other words, this notion of by the lawful judgment of his equals. That's the trial by jury. And that became the essence of the most important. You can't do something, okay, and let the king do all what he wants to do. And this notion of due process, okay, was so critically important that he needed to be able to do the same kind of thing, okay? You had to have some kind of basis for someone having committed some kind of violation before you could imprison or put someone, okay, and do something against them. You couldn't do that. You had to say that they had committed a crime, and that crime, okay, was something that was understood to be a crime. And then, clause 40, to no one will we sell, to no one deny or delay right of or justice, the right to a fair and speedy trial. In other words, you can't just put someone away and forget about them. And this is where the notion of a speedy trial became important, as well as the notion of a fair trial. So the Magna Carta became very important, and it kept every king that came after John kept being reminded of the Magna Carta, and it kept on getting new clauses, and some clauses were eliminated, and then some kings kept violating them, and there were some times, okay, where the Magna Carta was kind of even forgotten, but our founders and framers, they didn't forget it. They looked, okay, at this Magna Carta and they said, no, we need something like that in our government. And they brought it back, and they wanted it to be useful. Then there was the Petition of Right in 1628. Another king, King Charles I, was abusing his power, and you can see what abuses he gave, because you can see, okay, how Parliament was pressuring him to stop things like, you can't tax without our consent, Parliament's consent. Because obviously, guess what Charles was doing? You can't arbitrarily imprison someone. Guess what Charles was obviously doing? No quartering of soldiers in civilian homes. Guess what Charles was doing? And no martial law during times of peace. So all of these kinds of things, okay, tell us these abuses that were going on, and Parliament, the representatives of the government, were basically saying no to the king. Again, this didn't solve every single problem. A lot of kings still kind of pushed the envelope wherever they could, but the bottom line is these were things that the founders of our country were aware of, and they wanted to make sure that in the government they were forming, that these kinds of things, okay, would be corrected. Habeas corpus, you've heard that term. It's a Latin term to say, I have the body. What does it mean? It just simply means that if someone is going to be taken and by authorities, they have to go to a court to determine whether or not they have indeed committed a crime. So there has to be a judge, okay, who looks at and sees whether or not there's any kind of evidence that a crime was committed. So Habeas Corpus Act, okay, was something that was, again, needed because, again, Charles II, after he took over the reign, after Cromwell, okay, was removed from office, and the restoration, if you will, of the Stuart monarchy, he Parliament, okay, passed this law. Well, this became important to our framers, and they put that into the Constitution. So imprisonment of individuals without due process of law was common. If you spoke ill of the king, they put them in jail. So the act dictates that individuals must appear before a judge to determine if imprisonment is legal. So the Glorious Revolution is 1688. I gave a little bit of history here only because in some ways it's kind of important to understand what goes forward. James II was a Catholic king, considering the fact that Protestantism had really begun with Henry VIII in the early 16th century. Well, the response of many of the English people to a Catholic king was not very well received. And so there was a bloodless revolution. That's why they call it a glorious revolution, where James II was kicked out, and he did not fight it. And his daughter Mary, who was the wife of William of Orange, Orange being in the Netherlands, was going to replace James II. And so ended up, they made a deal with the Parliament, and that deal implied that the Parliament would now be supreme over the monarch. So the absolute monarchy that existed in England ended, and it became now a constitutional monarchy. And this is important as we go forward into the 18th century, because now it's no longer an absolute monarchy, it's now a constitutional monarchy. And now the Parliament is supreme and dictates pretty much, what's going to go on. And of course, when we're dealing with the American Revolution, it's Parliament that makes most of the rules, if you remember. Well, the following year, the English Bill of Rights is going to be created. And I write them here because I think many of what's in these Bill of Rights are going to ring a bell with most of you. So the rights for individuals, they have the right to petition the king. They have the right to not have excessive bails and fines. There is a clause saying there should be no cruel or unusual punishment. There needs to be impartial juries and freedom to bear arms for self-defense. Parliamentary rights. There needs to be free elections for the members of Parliament. Members of Parliament can speak freely in Parliament. In other words, they can say whatever they want and they can't be arrested for it. So even if they call the king a big baboon, they can't, go after him. And they can raise a standing army, with its consent. In other words, bypassing the king. So all of these are parts of the English Bill of Rights. Notice, some of the verbiage is something that you will see later. The Constitution articulates principles agreed upon and lays the groundwork for the institutions that will be created to actualize those principles. And that's the reason why I separate my talks into two talks, one on principles and the next one will be on the institutions. So we'll talk more about the institutions next week as to how they work and that type of thing. so that it makes more sense. So today we'll talk, okay, on the principles before discussing the institutions next week. So I'm going to ask you right now, what kinds of principles would you expect we're going to be discussing in discussing the Constitution and the Bill of Rights? What are you going to expect is going to be in the Constitution? And at least we'll start there, but you can even say the Bill of Rights. What are you going to see? What do you think you're going to see in the Constitution? Yes? No? Yes?
Rights and responsibilities.
Rights and responsibilities. Any specific ones? Yes?
Just freedom of speech,
Freedom of speech,
petition the government,
petitioning the government,
freedom of religion,
freedom of religion,
Press, freedom of carrying a gun.
to redress. Sorry, I'm losing that one. So I'll
Okay.
stop there.
You're well on your way.
No search and seizure.
I would expect to see something, I don't know if I'm on target or not, surrounding taxation or property rights, things like that.
Okay? Okay, anybody else?
Mutual defense.
Yes.
Freedom to bear arms.
Freedom to bear arms,
And militia.
Self-government.
self-governing, okay? Yes? Voting? Anything else?
Yeah, personal representation.
What's that?
Separation of powers.
Separation of powers? Well, that's good. Let's go see. Anybody else?
Separation of church and state.
Separation of church and state?
Funding,
What's that?
financing the government.
Financing? Okay, let's go see what we're going to find. So whoever says separation of powers, okay, is right on target. That's the first one we're going to talk about. That's certainly one of the principles that they're going to be bringing about. Next week we're going to dive into, okay, what each of these branches of government are about. But tell me, okay, what does each one of these do? We have 3 branches of government.
Legislative grace.
What is it?
Congress sets the law, the executive executes them, and then the judicial decides if they're constitutional.
Okay, that's good. So they each have separate functions. That's important. Separation of powers. So the legislature, okay, makes laws, okay. The executive branch, okay, executes, you said, or enforces the laws. And we have the judiciary, okay, interprets the laws, okay. So basically, each has 3 separate functions. So we'll leave that for next week to go into more details. A second major principle is checks and balances. Oftentimes we kind of link them together, but they're quite separate in their importance, because now the checks and balances means that one branch can check the other branch. And so I didn't give you more than one example just to allow you to make sure that you understand how that's being done. So, for example, if you're looking at the legislature checking the legislature, the House checks the Senate checks the House. What do I mean by that? Yes.
The House votes on a law, sends it to the Senate decides whether they want to pass it, then they send it back to the House again.
If they made a change to the House legislation, it goes back to the House, because it's got to be the same language. So, and I'm glad you said it the way you did, because if it's a money bill, all money bills have to originate in the House. If it's any other kind of a bill, it can originate in either house. So, but your point is, the House passes a law, or passes a bill, let's say. Then it has to go to the Senate. The Senate says, yeah, this isn't such a bad bill, but we're going to change a couple of clauses. And then it says, well, we got to go back to the House, and then they've got to, okay, vote on the Senate version. And if they don't like it, or they've got to go back to the Senate, and that's why it keeps going back and forth, or they go to what is called a conference committee, which means members of the House and members of the Senate come together and they, okay, work on the bill that they think is going to be amenable to both. And then they both vote on the same bill, and if that passes a majority, we're golden, right? It's now a law? Ah, no, because then the executive has a check on the legislature. The president might say, good job, guys. It's a bill. He just has to approve it. But if he doesn't, he vetoes it. If he vetoes it, that's it. Game's over. Oh, not necessarily, right? No, because now, okay, it goes back, okay, to the legislature. And now what do? 2/3, not a majority anymore. 2/3 of each, okay, house. And if they do 2/3, then they have overridden the veto, and it does become a law. No wonder it takes so long. But that's, okay, the way, okay, the Constitution was written. But that's examples of the checks, okay, and the check and balance. The legislature also has a check on the executive. The executive says, I want to nominate these judges to be on the Supreme Court. All he has to do is nominate? No. Because he goes to the Senate, not the House, just the Senate. The Senate will hold hearings, and the Senate, okay, Judiciary Committee will then discuss, okay, if that committee says okay, then it goes to the full Senate, and the Senate then votes on whether or not to accept the nomination of that particular, okay, nominee. And if that's the case, then, okay, he or she would then become a member of the court.
And that's just a majority vote?
I think so. I think so. I think it is only majority. But that's true of ambassadors, by the way. It's true of other appointees like cabinet members. Those are all, okay, all have to be approved by the Senate. And they, I believe, are all majority votes. So these are examples of the checks. The other check is the judicial also has a check on the legislative and the executive through what is called the judicial review, which we'll talk about a little bit soon, in a little bit. The judicial review process means you got to figure out whether or not is this a valid law? Is it constitutional? And the judges interpreting the law has to say, okay, is this according to what the Constitution says? So the judges have the right to do that. Now, do they do that automatically? No. Somebody has to say, this is not a good law. And they have to bring a case to the judiciary and the Supreme Court, and they have to agree to take the case. And that's where the determination is made. Does that make sense to everybody? you said executive orders, by the way, before, when you were talking about, if the president has an executive order and somebody says, we don't think that executive order follows the Constitution, then someone, another court or someone, legal team, can turn around and say, that executive order does not follow the Constitution. They can go to the courts and they can say, that should be determined as to whether or not it is constitutional or not. So that can follow the same checks and balance that we're talking about. Yes, sir?
Couldn't you muddy the waters by doing that to any law that's been passed then?
Of course.
You know what I mean?
But the court does not have to accept the case. In other words, there has to be 4 of the 9 judges, that are willing to take the case. So there are times, where the court, does not have 4 judges, that simply say that this is worthy of their what they call the writ of certiorari. So they don't have to take the case. So that's, in other words, the court, and these figures could have changed over the years, but the court has oftentimes got 4,000 cases that come to it every year, and they only do less than 80 cases a year. So that means that they deny a great number of cases that they actually review. So that they don't see every single case that comes that they have. Now, there are a great number of other principles. Trial by jury. I wish we could find a way to tell the American people that the trial by jury is one of our most important duties. Anybody tell me why I think it's one of their most important duties? Voting is probably most important, right?
Civic participation?
Participation, yes, but for what reason? Yes. What's that?
Equality and not inequality.
Well, you're getting close to the reasoning. What is, when we talk about consent of the governed, yes. You're right on, Just follow through on that thought, because this is the opportunity of the people to make sure that the government is doing its job. Just think about it. If there was no trial by jury, who's making the decision? The government. The trial by jury means the people are making the decision. If there was no trial by jury, it means that the lawyers and the judges are making the decision. The trial by jury means the people are making the decision. That's a great duty that we have. And we don't talk about it enough to recognize the importance that we have. Unfortunately, we look at it as, oh my God, do I have to? I hope they're going to pay me.
I'll have a job.
I hope it doesn't last long. Grand jury? I'm out for a month? Heavens to Murgatroyd. Habeas corpus, we've already explained it. Very important. Independent judiciary. If the king appointed all of the judges in England, if the judge made the wrong decision, which means didn't agree with the king, he lost his job. An independent judiciary means, he gets it for life. Good behavior, it's called. Now, that's true on the federal level. On the state levels, that's different. You live in a state, okay, where you have an independent judiciary. There's only 12 states that have independent judiciaries. 38 states vote every 2 years, most of them, and they vote on judges. How many of those judges do you think are following the popular will? You wish. 26 years ago, I worked on a video or program called Frontline. You know Frontline?
Yes.
Yeah, I worked on a program called Justice for Sale. Okay. And I worked on that, okay, for that particular program as a consultant. It was an eye-opener, let me tell you. When I saw, okay, how, okay, justices who had to campaign every 2 years to get reelected, and how, okay, those kinds of elections meant that they obviously had to make rulings that appeal to the public. Think about it. Veto. I think you understand that. Just one way more, okay, for another set of eyes, if you will, on legislation. Amendment power. Our amendment, okay, allow for the changes of the Constitution. It doesn't happen very frequently, as we're going to find out next week. It takes a long time. We've only got 27 amendments. 10 of them, okay, were done in 1791, 1790. Okay, so that's only 17. And the last one, okay, that we had was, what, 1971, 1972? Freedom of speech in Congress. That was important. That means that anybody who speaks in Congress cannot be arrested for what they say. Terms of office, 2 years for the House, 6 years for the senators, 4 years for the president. And of course, after the 1952, I think, we changed with an amendment, can't serve more than 2 terms. Supremacy clause, important, Article 6, okay, of the Constitution. To avoid chaos, the United States Constitution and its treaties are the supreme law of the land, meaning that every state must make sure that their laws do not conflict with the United States Constitution or its treaties. Bill of Rights. You're going to have fun with this. First Amendment. Everybody loves the First Amendment. I hated it when somebody said that people knew all the characters on The Simpsons more than they knew the First Amendment rights. Did you hear about that? So anyways, I want you to tune in to the first 5 words of the First Amendment. Surprised? And what do you think it means? Very few people, okay, recognize or realize, okay, the importance of those first 5 words.
It's restricted.
Exactly. The bottom line is, we talked about constitutionalism, didn't we? In other words, We always think about the Bill of Rights as a whole bunch of rights that we have. These are the rights that we have, that we can do whatever we want, right? The way in which it was framed is, Congress shall make no law. Meaning, they are limited in what they can do. In the first one they put up there is the freedom of religion, but there are two parts to it. They can't establish a religion. So, any religion can exist in this country without any problems. Supposedly. And you can exercise your right to believe and express those rights. You can believe as you wish. Now, I'm going to be the first to tell you, there are many lawsuits, okay, that have been gone through the years, okay, that have limited some of these rights, okay, only because, there are some reasons and concerns that people have had. And some of them are way out of balance. So that, some people, okay, take a look at, reading the decisions and hearing what other people say about the decisions can often be quite different. Engel versus Vital has been, okay, the 1962 case that somebody says, okay, is the case that banned prayer in schools. Some people will argue, okay, that decision, okay, was the end, okay, of religion in schools. That wasn't the intention. It's never, okay, what the intention if one reads, okay, the decision. The decision was that a prayer that was written, was intended to be non-denominational, that prayer, okay, could be offensive to some people. Because the state of New York, writing this prayer, was trying to be as non-denominational as possible, but there were people that would and could be very easily offended by that prayer, and they simply said that okay, would be offensive to some people, and therefore it should not be done in the schools for everyone collectively.
What year was that?
1962, I believe. So the bottom line is that it introduced a cavalcade, okay, of interpretation, an unintended one. And so the bottom line is the Establishment Clause was interpreted by those justices as meaning the government is not in the business of trying to, okay, advocate for any particular religion. It was intended, okay, to make sure that no one is going to feel intimidated by religion. And that was the sole purpose behind it. So we've had many, many cases. We've had cases in, where the creche scenes, okay, in Rhode Island, okay, were deemed to be offensive. And of course, that upset a lot of people. So again, was that a common good versus individual right? So, in other words, there's a lot of information and detailing, okay, of those kinds of issues, non-intentionally aimed at those types of different things. Where does government have the right to do that? Where does government not have the right to do that? So, does the government have the right to therefore make sure that Christian beliefs which are dominant, okay, within the country, do those particular beliefs have the right to be displayed when that may offend, okay, 30% of the population? So again, these are the conflicts and the notions, okay, that were in the view, if you will, of what is intended in the decision-making of that particular time frame. Not easy. And I'm not trying to say that these kinds of decisions are supposed to be easy. But those are the kinds of things, okay, that are part of the decision-making given the interpretations, okay, of what does the Constitution say, what does the Bill of Rights say. It says, do not abridge freedom of the press, freedom of the speech or the press. Well, we do abridge it. Okay, we do abridge, okay, those rights. There are certain things that you cannot say. And we understand that those are the kinds of things that you cannot say. But the bottom line is they have court cases that they have to look at for the purposes of why is it that you cannot, okay, say or do certain things. Do you allow someone, okay, to release information that tells people the plans that the United States has in attacking another nation? Is that freedom of the press? So all of these kinds of things and all of these things that need to be navigated are part of the decision-making that our courts have to make. To peaceably assemble, to petition the government, and I added to associate. And the reason I added that is because in 1958 there was a court case called NAACP versus Alabama. And the reason that case, okay, came up is now you can associate with any organization that you want, but in that particular case, Alabama wanted to know every single member that was part of the NAACP in Alabama. And guess what their reasons were? So the court just looked at that and said, this is going to create, okay, difficulties for all those people. This is not protecting those people. So as a result, this new right, if you will, came about through the interpretation of the court that your associations, okay, with different organizations should and cannot be released to the public. In other words, they can't be forced to be released. And that decision came in 1958. The Second Amendment. Ho! Do we dare? I mean, it's very interesting. Look at the reading of it. The first part is very clear. Okay, the right, well-regulated militia, being necessary to the security of a free state. Militia interprets today to the National Guard. Okay, that's what that means. That's how we interpret it. The right of the people to keep and bear arms shall not be infringed. If you take them separately, okay, one can easily understand why there's confusion. Now, until 2008, the interpretation was collective, meaning the interpretation was always along the line of the militia. That's how that was interpreted by the courts. And they didn't touch it since 1932, because that was the interpretation. In 2008, the Heller case, okay, changed the whole dynamic, okay, of the interpretation. Now they interpreted it according to individuals. And so now they interpret it with a heavy leaning toward the second part. And that's the interpretation that we have today. I'm skipping over the third because that really doesn't have a lot to do with quartering of soldiers. But the fourth through the eighth, a lot of people I've had discuss with me over the past and say, how come our framers were so obsessed, okay, with the rights of the accused? Because they were fighting an American Revolution against, okay, someone that if they had lost, things wouldn't have gone their way. So things wouldn't have looked very good for them. So therefore, they were concerned about things that would have gone bad for them had they been on the opposite side of losing the war. And then they were also concerned about everything that I talked to you about beforehand, about the things of how a monarchy or a authoritarian type of government would handle cases in which you might be accused of a crime. So look at it that way. Fourth Amendment, based often on one of our most unrecognized founders of our country. His name was James Otis. He was one of the first founders to really start arguing about British abuses. 1761, he got really upset with the British in the things that they were doing. You may have remembered when you were in school, you may have remembered reading about the writs of assistance. These were warrants, okay, or not warrants, of soldiers coming into people's homes and basically, okay, taking taking a look at everybody's, okay, what they had, arresting people, and just, okay, not giving anybody any of their rights. James Otis wrote vehemently against this in the early 1760s. Unfortunately, he had an accident and hurt his head that led to some insanity, and unfortunately, okay, really lost, okay, his mind. And unfortunately, we don't hear much about him, but his value as a founder is often mentioned by especially John Adams and Thomas Jefferson as in some ways having been the real inspiration to some of the reasons for the going against the British. Look at the words of the Fourth Amendment. Look at the detail of what the Fourth Amendment requires of people who are going to stop you to make sure, okay, that they're doing their job properly. The right to be secure against unreasonable searches and seizures without a warrant and with probable cause supported by oath or affirmation, describing the place to be searched and the persons and things to be seized. In other words, no law enforcement person can come up to you without a warrant, without saying by oath to a judge that this person that they're looking at, the items that they're looking for, are definite that these are the things that they're required to find, describing the place that they're going to find it, the people, and the things that they're looking to search and to find. All of these things are in the warrant. Detailed. This is what the Fourth Amendment requires. Now, because of a lot of different things that have happened, okay, the 20th century, the 21st century, there's been a lot of changes, okay, that are necessary with this. However, the basis of what we call the right to privacy is often pertaining to the Fourth Amendment. This notion of right to privacy is often found within this Fourth Amendment. John?
Do those rights apply to just citizens? And that's the bigger question, or a lot of these rights applying to just citizens?
This right applies to everyone. This does not apply to just citizens. This is person. Every person. Yep. This is not applicable to citizens alone. And understand the following. This debate, okay, shouldn't even be a debate for the following reason. If our laws applied, okay, to only citizens, imagine how unequal and how easily we could abuse those people who are not citizens by simply, okay, avoiding these rights and being able, okay, to get away with all kinds of abuse by doing these kinds of things. In other words, think about it in terms of everything that we talk about with regard to the laws. If we strictly had laws that applied simply to citizens, every person who was an immigrant here legally but yet not a citizen, all of these people, okay, would be so easy pickings to be able to abuse and be able to take advantage of, simply because in many cases they are. I mean, the trafficking of people that goes on in this country now, even though they are protected, avoids some of these things simply because they can do it. If they were to be caught, these would apply. But if they didn't apply to non-citizens, where would the equality be?
So the real question today, of course, and you probably don't want to go there, but where are the checks and balances happening today? When we read the news, it's just so frustrating.
The question must be in the hands of the people. Knowledge.
Question. Roger? Question.
Yes.
I think about what you just said, not just citizens, not even immigrants, visitors to our country.
Correct.
I mean, look at the things that have happened around the world.
Absolutely.
People go to other countries. So
Absolutely.
The protection of someone coming into our country. And if this is a detour that we can't take, I respect that. But, ICE doesn't need a warrant, yet without a warrant, like, where do we go with that situation?
Knowledge and understanding empowers. We can only do what we can do, but we must have the knowledge to be able to claim our own. That's all we can do.
So the arrest in Worcester, you know, people screaming warrant and being told ICE doesn't need a warrant. A woman's taken, if they don't know where they are, her children go in DCF custody and run away. One of them is returned. What more can I do? I'm not putting you on the spot, I don't know.
The bottom line right now is we need to learn and understand and know more about what our government is all about and what our government stands for.
Because we were all immigrants.
Well, yes, but the bottom line is knowing what our government stands for is important. My gravest concern is if we do not know what our government is about, we will not be able, okay, to be able to confront whatever issues need to be addressed. Yes.
I grew up in Spencer, and I married somebody from Millbury. My equivalent of Roger was someone who I remember as Bionic Arm Holbrook, because of the speed at which she would put notes on the board. I learned this in a citizenship class from her. And the number of people that I've run into in the past few years who have no concept of how this works, because they didn't have a Roger or a Bionic Arm Holbrook. I wish I could remember her first name. It would be very much more respectful, but I can't. But you know, what I learned from her and what I'm relearning from you and what you taught my kids, it's allowing me to have difficult conversations with people. It's really easy to get pissed. It's really easy to cut people off. My childhood best friend, who means the universe to me, is a polar opposite. And we have difficult conversations. I have them at work, I have them in stores. You know, it's awkward and it's tiring. And I am so flipping tired, but like, thank you for doing this, because you're right, we have to be able to have conversations with people. We need this.
The bottom line is patience and understanding. There are people who will disagree mightily, okay, with what we say and what we do and what we understand. They are, or I say they only because of what you just said, but the they means how many years of frustration have they gone through to reach the time frame that we are in?
Yeah.
In other words, they may very well be good, very good people. And I know very good people, okay, who may disagree with me.
Yeah.
But the fact of the matter is that they have 40 and 50 years of having been warped, in my view, with, okay, an ideology or an understanding, okay, that is not going to change, okay, very quickly. Part of it is because they don't understand what our framers were doing. That's my view. They don't understand, okay, why our founders, okay, were doing when they set up the government that they did. Unfortunately, many are probably not willing to listen to that now. But the fact of the matter is that our founders, as flawed as they were, I mean, let's not let's not, okay, let's not think of them as, they didn't think women, okay, should be part of government and should not be, okay, understanding. They didn't think that black people, okay, were good enough, okay, to be free people. Let's understand that. But we came and have come a great deal to the point where we are able to recognize that all men and all women and all races and all peoples of all religions and ethnicities who have come to this United States, okay, have the rights that everyone should have. And when I die, I hope that there is not going to be a heaven where black people are going to be in one place and women are going to be in one place and others are going to be in a different place. I have a feeling that everybody who's going to be in heaven that's a good person are all going to be together. Because if it's not that way, then everything that I've been taught and everything that I have seen in my life, okay, has been for naught.
And thus the words, thy will be done on earth as it is in heaven.
So the bottom line to me is that message, okay, needs to resonate far more than the message of division.
Gotta keep talking, keep going. Keep doing it.
And that's the best I'm going to go as far as that. Fifth, Amendment 5. Capital crimes must be presented on indictment of a grand jury. So we have grand juries. Grand juries operate, okay, very difficult. Now, this is an option that people have. If they have if they have committed a crime, they have the right, okay, to have a grand jury to investigate whether or not, okay, the crime that they're being accused of, okay, has enough evidence. So the only problem with the grand jury is the only people that bring out the evidence is the prosecution. So the defense has no role. Only the prosecution brings out the evidence. But this is the choice that is made in order to determine whether or not there's enough evidence. So this can be utilized, okay? No double jeopardy. Understand, okay, and that is not as clear-cut as what that states. But for the most part, it just simply means that you can't be tried for the same crime twice, okay? But the bottom line is, if you're a rapist and you've been charged with rape and you were, okay, convicted, but you also committed kidnapping, but you weren't charged with that one, and they want to charge you for kidnapping, you can be, okay, put on trial for kidnapping. So the bottom line is, you can't be charged for the same crime with the same, okay, you can't be charged for the same crime twice. But if you have another crime that they've committed and they didn't charge you for that one, it can be charged. No forced self-incrimination. Everybody thinks that if you plead the fifth, you must be guilty. That's not the origins of that, okay, decision. The reason for that is when it first was used, there was a double jeopardy, so to speak. If you were, they had star chambers in the 17th century in England. And in England, okay, these star chambers, they would force you to say that you had done something, even if you hadn't. They forced you to do these things. And so the bottom line is they put these provisions of not having to self-incriminate, because the forcing of someone to confess to something that they hadn't done in order, okay, to expedite the trial, okay, was causing innocent people, okay, to get, okay, convicted. So they started to use this in the 17th century. So it's carried on And we've carried on that. But today, a lot of people feel that if you're using that, okay, that clearly indicates in people's minds that means, okay, you are guilty. But that's not necessarily the case. Forced confessions falls under this. Okay, there's a lot of forced confessions. I've read a book recently. I don't recommend it for anybody who feels like they want to hear about law enforcement not doing their job correctly or judges not doing their job. But Framed, written by John Grisham. It's a tough book to read because it just shows, okay, that sometimes the people that we trust most, okay, to do the right job don't do it. And it's a tough one. But it's our human nature. But please understand, okay, that this human nature is such, okay, that people don't do the right thing all the time. The next one is extremely important. No deprivation of life, liberty, or property without due process of law. It doesn't matter when you are arrested, when you are held, when you are taken by anyone, by law enforcement, you are required to be given due process of law. That is a requirement by federal law, in the 14th Amendment by state law. Okay? Hopefully we'll get to that. This is extremely important. So anyone, okay, that gets arrested, taken, okay, and just, okay, moved along and does not get due process of law, that means being taken before an authority, could be a judge, but any authority, and being said, okay, what has this person done wrong? What crime has this person committed? What evidence do you have? And if there's something that they've done wrong, then they are then going to be allowed to carry out whatever, okay, they were told to be carried out. Finally, eminent domain. So again, this can be very controversial, but the bottom line is eminent domain simply means that people can take their property, the government rather, can take their property if, okay, there is a common good, okay, type of issue that is involved. In other words, if there's just cause, okay, for it to be taken. For example, when they built the Mass Pike in 1950s, a lot of people lost their homes. They were compensated by the government in order, okay, to replace their homes and relocate, etc. Now, did people feel as if they got the value for their home? Most people, question that. But the fact of the matter is that was under Amendment 5, eminent domain. But that's typically, okay, where they get that particular right. Now we have a whole series of criminal cases that are protected. Some of these, okay, you might be surprised, okay, of their importance. A right to a speedy trial, a fair trial, a public trial. A speedy trial, sometimes we question that, but be careful about that, because sometimes the reason why it's not speedy is because the defense doesn't have enough time to get the information that they need, or the prosecution doesn't have enough time to get the information that they need. So speedy is supposed to be within 100 days. I don't know if that's really what's happening. But the fact of the matter is, a lot of things are dependent upon, okay, what the lawyers are able to do. We've got an issue in the state right now, okay, where the public defenders are not getting a fair wage in their minds, and so therefore you don't have enough public defenders, that's going to be an issue. How does that deal with, okay, the notion of a speedy trial? Public trial, very important. It may seem, okay, innocuous to us, but the fact of the matter is, a public trial for them at the time in the 18th century when they were writing this was very important. Why? Because often in the 17th century, the king, okay, would have trials that were not public, they were private, and people didn't know they were even happening. And so you don't want, okay, those kind of things. So that's why those are inserted within the Bill of Rights. An impartial jury. You want the trial to occur in the same area and district where where the crime was committed. And so that is part of what's there. Now, of course, a change of venue can occur if there was too much media attention or something where you don't feel as if you can get an impartial jury because of what's going on. Those kinds of things do allow for a jury to be selected outside of the district. Need for to be informed of who's accusing you. In other words, it's important to know who has accused you of the crime. These are very important notions. Sometimes, okay, someone's said this is the crime you've committed, but you don't even know, okay, how this came to be. So you want to know where this person is, because your lawyer is going to want to be able to see whether or not that person's impeachable. So those are important values. Who are the witnesses testifying against you? Who are the persons testifying for you? Because sometimes the people that should be testifying for you don't want to testify for you. So you've got to be able to make them testify for you. That can be difficult, okay, in order for you to be able to have that. And then the need for assistance of counsel. So especially the poor and the needy, okay, need some kind of lawyer, and so that kind of stuff. So the Sixth Amendment is packed with a lot of importance. Amendment 7 is for civil cases. Right of trial by jury is preserved for all suits of value exceeding $20, according to the rules of common law. Seems a little cheap, doesn't it? Well, I did look it up, and $20 in the 1700s would be $692 today. So a little bit higher. Amendment 8 looks a little bit familiar to you when we looked at the English Bill of Rights. Okay, no excessive bail, nor excessive fines, no cruel or unusual punishment. The 10th Amendment, by the way, I skipped over the 9th. And the 9th Amendment, okay, simply said, when they were looking at how to put all these amendments together, they figured out, well, let me put one down, because who knows, there might be need of other amendments to come up, so they put a amendment that said, the 9th Amendment is for any other, okay, types of rights that you might need that we didn't cover. And of course, they haven't used that amendment in the Supreme Court for fear that if they start using that amendment, okay, there'll be an avalanche of rights that people will want. So they haven't used the 9th Amendment. The 10th Amendment, of course, is extremely valuable because that is the issue of federalism. And federalism is an amendment, okay, that talks about the difference between the states and, of course, the national government. So the powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states respectively or to the people. So the Article 1, Section 8 of the Constitution specifically outlines 17 specific powers that the Congress has, and then one that we'll talk about next week. So there's just 18 clauses. And then the powers prohibited to the states are found in Article 1, Section 10, and then it's printed there. Those include, you don't want the states making treaties with other countries, because they're not allowed to go to war anyways, right? So they're not allowed to coin money, not like before the Constitution where Rhode Island, printed all kinds of money. So when Rhode Island came to the United States, when they came to Massachusetts to buy things, their money was so cheap that the Massachusetts vendors refused to take Rhode Island money. Well, I've got $100 right here. Yeah, but your $100 isn't worth one of our dollars. So, you can't coin money, you can't print money, you can't nullify contracts, you can't grant titles of nobility. So all of those are things that the states can't do. Bottom line is the states are basically responsible for what is called police powers, things relating to health, education, and welfare. Of course, that's no longer true, since the federal government's involved in health, welfare, and education. So that was true, but for some reason, it's no longer true. Other key principles. So, tell you what, we're getting late. I can cover this at the beginning of next week, because it's been long, and allow for you to ask me some questions if you want before we close for the night. You want to do that? I can do the other principles at the beginning of next week. How's that?
Sounds good.
It sounds good? Any questions? Seeing none? Oh!
You had term limits up there. When did they abolish term limits in Congress and Senate?
They have not. Term limits are, I didn't say term limits. I said terms of office. Terms of office, are 2 years and 6 years for the Senate. There are no term limits, for the House of Representatives or for the Senate. There are no term limits for the judges. They're there for good behavior. Who knows? I'm not sure how to interpret good behavior. I'd put them in the corner. Anyone else? Seeing no other hands. Yes?
I don't have a question. I just want to say thank you. This has been
Thank you. And I will acknowledge you're very gracious. I think it's so important, and I thank you all for your attention. I thank you all for your willingness to come out and spend a couple of hours, to go over what I think is quite essential. But I thank you so much, and thank you all for your great comments and remarks. Since last week, it was quite gratifying, and I am so thankful for everything. I have people in Kansas and people in Oregon who are going to use these tapes for their own purposes. I've also got people in this state that are going to be doing some work in their communities. I really, an army of one is not going to do a lot of work. So it's really important if you know of people, that can do this in other communities. In my opinion, in my humble opinion, we need more, people to hear and listen and learn more and more about, what our government is all about, and hopefully regain, the sanity of our government. So
maybe next week or the last week, you could help us. Some people may already know because they're very actively involved, but help us help be a part of the network to support the work that you're doing in terms of sharing, distributing, financial, just, before we wrap up, I think that's really important.
I'm going to ask if your point is excellent, and I'm going to ask if Tracy wouldn't mind doing this. If when you register, when you come in and take your name, if you could put your email address, okay, and give it to her, and then, okay, we could probably continue a conversation going forward. For those of you who are willing to do that, then I can, okay, keep you informed and then keep going with this. And yeah, our organization, okay, is trying to pursue as much as we can, what we can. And as you said, it takes a lot of energy. And if I can get others to do this, I'd like to be able to give them a financial impetus to be able to do it, because it really is, okay, it is a lot of work, and I would like to be able to help them to do that. It's vital. I'm going to say it that way. It's a vital, important time that we're living in, and I look at it as Benjamin Franklin said at the end of the Philadelphia Convention. Okay, a woman came up to him and she asked him, "What kind of government do we have?" And his response was, "A republic, ma'am, if you can keep it." And that's where we're at, folks. That's where we're at. If you can keep it. Thank you.
Thank you.